Supreme Court cases are quietly reshaping America. We're going to talk about what's going on with these cases and what that means for us here in America. So let's get right into it. Well, welcome to Cutting Edge Faith. I'm Ryan Howard. This podcast is here to help you understand the times, stand for truth, and grow your faith. And we want to help you understand what's really going on, which means we need to know what's going on. Got after people who understood when it was going to rain. They understood the times and the seasons, but they did not understand that the Son of Man was standing before them because they didn't really see what was going on. And we want to be like the sons of Issachar, where we understand the times and they knew what Israel should do. So I want to help you understand the times with this podcast, and then you'll know what to do. You can be led by the Holy Spirit to know what to do. So let's jump right into this. The first case here, one of these was decided already, and the other one is just getting started. So the first one here is about banning transgender participation in sports. So this is pretty consequential. I mean, we've seen with whatever the swimming that happened with the NCAA that lost the title or tied for the title with the transgender athlete. And people oftentimes what they want to say is that, well, it's only a few athletes, it's not a big deal. Well, if they're taking gold medals, I think it's kind of a big deal. So what's going on here? Well, the U.S. Supreme Court, this title here appears sympathetic with state transgender sports bans. So on Tuesday, that was just a few days ago, the U.S. Supreme Court heard back-to-back arguments in Little v. Hecox and West Virginia v. BJP, challenging state bans on transgender girls and women's sports in school athletics with oral arguments in Iran. And so the justices questioned whether Title IX, that's the one that talks about having the equal sports between men and women in universities and schools, and it says whether or not that applies to transgender athletes. And it debated whether the federal sex discrimination law covers gender identity. And well, some of them are arguing that biological differences justify the bans to protect fairness, and I would have to say that I highly agree with that. And we're going to get into a little bit of some contradictions here from one of these people pushing this case. And so Idaho and West Virginia, since they enacted these bans, 25 other states have started enforcing their own bans, and 24 other states have passed similar laws, with some blocked by the courts. So this seems like it should be pretty straightforward, but a ruling on this could affect bans across 7 states, and advocates are warning that it raises a broader federal law question on privacy, sex discrimination, and school athletics policies. Well, it's interesting here. I want to get into, there was a post here that highlights what one of these engagements from between Justice Alito and the attorney here. And I'm going to go into some of that transcript because it's pretty crazy. But basically, they're arguing this case in front of the Supreme Court about Title IX, which is about equal treatment and fairness between the different sexes. And they basically get into, well, let's define what sex is. And she basically says, we didn't come here to define sex. We came here, and then she got into the word salad of what it was. But I'd encourage you to go watch that. It's about a 7-minute interaction. But let's go through some of what was said here. So the attorneys challenging the state laws barring male athletes from competing in women's sports refused to fully define the term sex when arguing the case. So this is just, I mean, you can't make this stuff up. But it says, Hecox, this case centers around trans-identified male, which would be a female, to strike down this Idaho law. And so if we go down here, it says, let's see, at one point, Justice Samuel Alito asked Harnett, that's the attorney, if she agreed that the school should have separate teams for a category for students classified as boys and a category classified as girls. And she said, yes, Your Honor. And Alito, he's got to be going somewhere with this. But he says, okay, if the school did that, is it necessary for there to be equal protection for equal protection purposes if it's challenged under the equal protection clauses and understanding of what it means to be a boy or a girl or a man or a woman? Yes, Your Honor, the attorney said. And when he subsequently asked, what is the definition for a boy and a girl for equal protection purposes, she said, I think the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state and the government was understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court, because he continued to press her. She says, we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams. So she says there's a subset of those birth sex males where it doesn't make sense to do so, according to the state's own interests, she argued. So then he went on to say, Justice Alito says, well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes? I mean, that's pretty straightforward, don't you think? I mean, how can we have this conversation even? Well, she goes on to say that challenging and back and forth, and then it says he asked her and says, he went into where it says should a boy, if a boy has never had any of these hormone treatments, or a girl that never had any of these hormone treatments, or a boy and they want to join the other sport, if a boy wants to join a girl's sport but he's never had these treatments, should he be allowed to? And she basically said no. And so then it's like, well, but she says, I would respect their self-identity, addressing the person, but in terms of the statute, I think the question is, does the person have a sex-based biological advantage? So what she's basically saying is, it's a little bit subjective. Is there a biological advantage? Well, we know that all boys have a biological advantage when it comes to sports. But what she's saying is, we need to actually look at the individual cases and then make a determination, which makes no sense at all. So he goes on to say that basically they're not arguing the definition and all that. And then the justice says, I don't think it follows that Title IX creates a national definition of sex that preempts the state's ability to say, actually, we are more concerned about discrimination than what happens in these gender roles. So they kind of go back and forth. But this was like a 7-minute interaction, and it was just more word salad. And so it just came out, and it's quite crazy to even think that this needs to be discussed at the Supreme Court. And so we see what happened here. It says the Christian Post reported last year that trans-identified male athletes have been awarded over 1,900 gold medals when competing in girls' sports and women's athletic competitions. So those would have been awarded to women. 1,900. If it was even one, that would be a problem. If it was zero, it would be a problem. We've seen other sports where, like boxing or other more contact sports, where women get injured. I mean, this is just insane. So it does appear on the outset here that this is going to go the right direction, and they're going to uphold these bans. Of course, it will get into the details of what those bans mean and some of the details there and how they can be carried out. But in the end, biological males should compete against biological males, and biological females should compete against biological females. So what do you think about that? Let me know in the comments, or if you're on the audio, go ahead and just hit the link in the show notes to send me a text message. So that's the first one. Let's talk about the next one up. And this one is about election integrity. We know that became a very big hot topic in 2020. But this one, basically, they just decided this week, it says candidates have legal standing to challenge election laws, the Supreme Court rules. So if you want to look at this, basically, in the past, what they've said is, a candidate doesn't have standing. Candidate doesn't have standing, and so what does that mean? So having standing in a court means that a party has the legal right or capacity to bring a lawsuit because they have a direct personal stake in the outcome, demonstrating they've suffered or could suffer a concrete injury caused through the defendant's actions. And so the court is ruling can actually fix that harm. Now, injury doesn't necessarily mean a physical injury. It could just be they had a negative repercussion against them. And you would think, of course, a candidate could have a negative repercussion against them. If the laws help another candidate win, that's a problem. So this is great news. Consequential. This is very consequential. So this case was brought by Illinois Republican U.S. Rep. Michael Bost and other candidates who wanted to challenge a law that allows election officials to count mail ballots that arrive up to 2 weeks after Election Day, as long as they're postmarked on time. 2 weeks after Election Day. It does not take 2 weeks to count ballots. It is absolutely insane. And so many states have laws that offer a buffer or a grace period to voters who have mail-in ballots and have issues with Postal Service. For example, a lower court ruled that Bost did not have standing to challenge the Illinois law, but the conservative majority Supreme Court in a 7-2 ruling disagreed. So think about that. There's actually America that said he did not have standing as a candidate in a race. Can you believe that? So Chief Justice Roberts authored the opinion, writing that candidates have a concrete and particularized interest in the rules that govern the counting of votes in their elections, regardless of whether those rules harm their electoral prospects or increase the cost of their campaign. So you can see there's a couple things that come up here. If those laws can cause more cost to a campaign, because maybe they got to get attorneys to get involved, or to find out if they even have standing, they got to spend money to even if they find out if they have standing. Well, this says they have standing, so it's worth challenging these laws. And even bringing cases against results. I mean, that's a whole other topic. But let's read some more here. It says, Justice Amy Coney Barrett wrote a concurring opinion, joined by Kagan, Brown Jackson, and Sotomayor dissented. Surprise there, right? Ketanji Brown Jackson, and Sotomayor dissented. So in her dissent, Justice Jackson argued that the court was giving candidates the ability to sue in advance of probable harm, despite the fact that most voters don't have that ability. Well, this stuff is pretty frustrating to look at, but it doesn't matter now because it has been ruled. And so a candidate that has a problem with an election law that is gonna cause a problem for them, well, they can go ahead and challenge that in a court of law. They do have standing. We can even argue that regular voting citizens have standing. So I don't know what you think. What do you think about this? Do you think these are consequential? Do you think these are important? I think that most of us know just clearly that it's a problem to have biological males competing in women's sports, and it's also a problem to have elections that we cannot trust, and to have things that I think next we need to talk about having voter ID, or even proving that you're a citizen to vote. These are things that, used to be way back in the day, you had to, if you wanted, you couldn't just anybody do a mail-in ballot. You had to actually have a reason to do it was called an absentee ballot. You had to have a reason, and you had to go beforehand and do that. I've voted while being out of the country. We have our military people that all the people there, they vote while they're out of the country. And so I've been able to do it, and you get in on time, you make a plan. It is not complicated. So there are times where you need to be able to vote from outside the U.S., or you need to be able to vote early, or you need to be able to do those sorts of things. But it's not everybody all the time, and especially not being able to vote late. There definitely needs to be a reasonable cutoff. And so thank God that we have some of these things go in the right direction. And what do you think? Let me know in the comments. And like I said, if you're on the audio, send me a link. Click the link in the show notes and go ahead and send me your thoughts in a text message there. Well, thank you for joining. I hope you enjoyed. God bless, and we'll see you in the next episode.